Good morning. Thank you. Please be seated. Thank you for your courtesy. This is the time set for oral argument on our case that was captioned Garcia versus Phillips, and our clerk's office has changed it to Phillips versus Garcia because we believe it should be in the same sequence it was in the Superior Court. So now it's captioned Phillips v. Garcia. We may send out an order on that, or you may just get our decision and it'll have the new sequence, same number, of course. And the number is, for our record, 1CA-CV140239. This is the time set for oral argument. Each side has 20 minutes. Counsel for appellant, Mr. Stein, is that correct?
Yes.
If you want to save 5 minutes or so for rebuttal, then we'll try to honor that, but you have to watch the clock and accomplish it.
Indeed, Your Honor.
So please proceed. The other thing I didn't say that I'll say while you're coming on up is that please say for our recording who you are as you begin.
Yes, and good morning, Your Honors. Henry Stein, attorney for the defendant appellant. As an initial matter, I want to thank the court because I was absolutely delighted to receive the order a couple days ago identifying those particular issues that the court was most interested in. It certainly helps focus argument today. And I will accept the invitation and pattern my argument along the issues that were raised. The first 2 points deal with jurisdictional issues, and if I might, Your Honor, talk a moment about that. The primary focus or the primary thrust of the appellate court's jurisdiction is 2101A3, that being a special order after a final judgment. Obviously, one of the key issues in this case was a final judgment ever entered. And it's our position that was not the case. However, it's our view we have a right to rely upon the Superior Court's determination that a final judgment was indeed entered. Several points in support. A, the court has set a supersedious bond in this matter premised upon a final judgment. B, the court scheduled judgment debtors examinations for Mr. Garcia, who I neglected to mention is present in the courtroom with me today. The court set a judgment debtors examination in reliance upon a final judgment being entered. And third point, Your Honor, our motion to dismiss, which brings us here today, expressly raised the notion that a final judgment was never entered within the meaning of Rule 58A of the Civil Procedure Rules, and denied that motion. Thus, we are here today premised upon the Superior Court's determination that a final judgment was indeed entered.
Do you have authority that says if the Superior Court thought it was a final judgment, but it wasn't, that becomes a final judgment?
I looked, Your Honor. I wish I could cite an Arizona case for that proposition. I cannot.
I think we have authority that says if there's some interpretation to be done of a document as to whether it was final or not, sometimes the clear interpretation of the trial court can be considered by us, but the denial of a motion to dismiss is sort of notoriously not appealable.
Well, do you know, not necessarily, and I'm going to cite a case. It's Sullivan.
Counsel, before
Yes.
you go on, let me finish up on this one question.
Yes, Your Honor.
Do you have any authority for us allowing for a final decision to be signed, a judgment to be signed by other than a judge or a court commissioner?
Your Honor, it's our position that only a judge or a court commissioner can sign a judgment, and such is in harmony with 12133 and Rule 76D. It's our position that the arbitrator's, quote, judgment was in reality either an arbitration award or was a legal nullity.
Of course, that cuts against your argument that we have jurisdiction, because that would
Your
mean
Honor,
there's no judgment entered.
Your Honor, that's our position. I mean, every party who is appearing before the court in one sense or another is alleging that the trial court made an error in one sense or another. We are here saying that the trial court erred in determining there was a final judgment. How then may this issue be brought to the appellate courts absent this court, for appeal purposes, accepting that a final judgment was entered? We certainly have the alternative argument via special action. But obviously, special action is a matter of discretion.
I take it, though, that that your position would be if we could decide we don't have appellate jurisdiction at this moment, that your position would be that we should exercise special action.
Indeed, Your Honor, and I think the three primary factors that address the issue of whether the court should accept special action jurisdiction squarely operate to suggest the court do accept jurisdiction and address the merits of the matter. But fundamentally, we are faced with a catch-22 proposition, isn't it?
Well, maybe.
Because if
we declared we had no appellate jurisdiction at the moment, for this case, in other words, for this appeal, either party could go back to the trial court and ask for entry of a final judgment of some sort.
Well, the court has concluded, the Superior Court has concluded there is a final judgment.
Excuse me for this, maybe I missed something in the record. I thought all the Superior Court did was deny your motion to dismiss. I didn't know that is it Judge Udall? I didn't know that he made some affirmative finding regarding the judgment signed by the arbitrator.
And I might have misspoke and overreached just a tad on that. The effect of his...
It might be a good inference, but I don't know that he said it.
Those words did not fall from his lips or find its way on a piece of paper, to my knowledge. But the implication of what the court has done by allowing judgment debtor's examination, by fixing a supersedious bond, by denying a motion, which was premised in part upon a failure to have a final judgment entered, all suggest to me, and suggest in a very persuasive fashion, that a final judgment from the Superior Court's perspective was indeed entered. And that's what brings us here today, of course, is my client is, for purpose of appellate jurisdiction, is between a rock and a hard place in many respects. The Superior Court, as a matter of maybe not practice, but a matter of what it has done here, has placed Mr. Garcia in the posture of a judgment debtor. We have pointed out to the court the judgment is invalid and the case should be dismissed. That was denied, and the court has proceeded with all inferences and all actions as if a final judgment was entered. However, in the event the court determines there is a question of appellate jurisdiction for a direct appeal, a special action in the exercise of discretion is appropriate. Of course, the form versus substance should control here. There is a legitimate controversy here, and a controversy which must be decided, and it's a controversy that is a matter of pure legal interpretation. It is not a matter arising under any sort of contested facts. The facts are not contested.
And in the interest of time, let's go to the substance here.
Absolutely.
Let me start that, if I may, but with this question. Let's assume we agree with your side's interpretation of Rule 76, that there really are three actions here, that the arbitrator issues a notice of decision, the arbitrator then issues an award or something else, it might be called something else, and then the court, upon application, or sometimes on its own, will issue a judgment.
Yes, Your Honor.
Let's say we agree with you on that, hypothetically, at least, but what about 12-133 that says the award shall have the effect of a judgment?
And those are the words, Your Honor, I was going to emphasize, has the effect. It does not say the award is a judgment. What the Supreme Court has done in adopting Rule 76D, or 76C, is enacting an implementation rule. The statute has two elements, one substantive and one procedural. The substantive element is you get an arbitration award in Superior Court, the time for appeal expires, therefore the substance of whatever the arbitration award contains is final.
Effectively, if it's not appealed, it becomes a judgment once a form of judgment is filed, correct?
Once a form of judgment is filed and signed by the Superior Court.
But how do you extract that from the language of the statute that says the award shall, and I probably need to get it in front of me here, and I will, but I'll ask it first. The award shall have the effect of a judgment.
It says shall have the effect. Now, it does not say it shall constitute a final judgment. Now, let me point out two things.
But it comes awfully close to saying that.
Close but no cigar, I believe. Let me point out two things to the court. Number one, the substantive provision of Rule 12-133 is what I mentioned. That is, after the time for appeal expires from an arbitration award, the merits of that case have been decided. The balance of that statute is merely procedural. It says what happens, what is the legal effect of whatever that arbitrator's award is, and the statute says it somehow mutates into a judgment. The Supreme Court, in adopting Rule 76, tells the parties, tells the court in unmistakable terms, in several portions of Rule 76, that the procedure to be employed is that the Superior Court judge, or perhaps a commissioner under Rule 58, shall enter a judgment. Now,
So I think I hear you saying, correct me if I'm wrong, that Rule 76, I'll use the word supplements the statute, and that the statute and rule can be harmonized.
Absolutely. I view it as an enabling statute, or an enabling rule, telling the court and the litigants how do we take an arbitration award, which is signed by not a judge or a commissioner, but by the arbitrator, how do we convert that to a judgment of the Superior Court? It cannot be any clearer in Rule 76 that a party within a specified period of time, 120 days after the notice of decision is filed, must apply to the Superior Court for entry of a judgment, and if they don't, the case is dismissed.
Why does the statute say the court shall enter the award in its record of judgments?
And I don't know why, but let me explain how it gets resolved, Your Honor. Because there is at least potentially a conflict between the rule and the statute, the first question is a conflict one of substance or one of procedure? If it is one of procedure, there is case law in this state that says the Supreme Court rule, when placed in conflict with a statute as to procedure, the rule shall have priority. And the case I would cite, Your Honor, is Patterson versus Mahoney. That is 219 Arizona 453 199 P 3rd 708 Division 1 Opinion 2008.
Sorry, could you give me the site again?
Yes, Your Honor. It is 219 Arizona 453 199 P 3rd 708 Division 108. So if we are confronted with a position where the procedural law, for lack of a better term, found in the statute conflicts with the Supreme Court rule wins. Now,
And we have to declare then that the legislature has violated separation of powers and their statute is unconstitutional, which, we kind of have a presumption that statutes are constitutional, not unconstitutional.
and I don't know that the court needs to reach that ultimate decision. They can be read in harmony. That being, the statute simply confirms that an arbitration award converts to a judgment in some sense. It doesn't say, 12-133 does not say that arbitration award shall, for all purposes, be a judgment.
But it does say the court shall enter the award in its record of judgments.
But isn't that purely procedural?
But then we get back to the conflict between the statute and the rule, because you just used the word harmonized. They could be harmonized, but now you're going back and saying, well, there's a conflict.
I am presenting an alternative.
So how do you harmonize, how do you harmonize the effect, excuse me, I understand how you're doing the effect of a judgment, but how do you harmonize the rule that says there are these three steps with the sentence in the statute that says the court shall enter the award in its record of judgments?
It is difficult to harmonize that particular term.
I think so.
And that is why I fall back onto the notion that that is a matter purely a procedure. And the Supreme Court, in adopting Rule 76, is presumed to understand what the laws of the state of Arizona might be.
Can I ask you this? You earlier addressed the issue of the effect and what your interpretation of the words the effect were. Does the entering of the award in the judgment, in the court's, I don't have the language right, record of judgment, could that also be read as shall enter the content of the award in its record of judgment? If we assume that the judgment has to be filed, the judgment has to be considered consistent with the award, then would it be the content of the award that is effectively entered into the judgment?
Into the record.
Into the record, excuse me.
Which will ultimately find its way into a judgment entered by the Superior Court. I am troubled by the notion that Rule 58 squarely says judgments must be entered by a court or commissioner. In this case, there is no question an arbitrator does not have the authority under the arbitration rules or under statute to enter a judgment.
And should that control?
I'm sorry, should what?
Should who signs the judgment control?
Certainly. Because indeed, at the time the purported judgment was entered, the time for appeal hadn't yet expired.
Because we're about out of time here, let me get to a further question for you. Let's assume we agree with you on Rule 76, and we believe that the statute and rule can be harmonized, and we remand for entry of a dismissal. Is it a dismissal with prejudice or without prejudice?
Your Honor, it's a wonderful question. I look long and hard. The rule, of course, is silent on that point. We would concede that unless the court would deem otherwise, it would be without prejudice dismissal. I don't find any authority for the proposition.
Actually searched, and we did find some cases out of New Jersey that has similar. Now, New Jersey is considered a foreign jurisdiction. I'm not sure we can cite it.
I've heard of it.
But, I have to take my passport when I go back there.
He might disagree with that.
There is a decision, at least as I read it, from New Jersey under similar rules called Allen versus Heritage Court Associates. I'm just letting you know, because 737 A. 2nd 1158 from 1999 that says it seems to say it should be a dismissal with prejudice, but then says the court should liberally allow a motion to extend the time to file the motion to confirm, or it could be, I guess, an order without prejudice under Rule 41B, which would then allow the person to somehow refile or file a motion.
And I'm wondering if that arose in the context of a private arbitration confirmation proceeding.
Mandatory
Was it?
exactly. We looked at the rules, exactly the same, and it said you have so many days to file a motion to confirm. Okay.
And if I might, Your Honors, reserve the balance of my time.
Yes, thank you very much.
Thank you, counsel.
Mr. Stein, please proceed. Mr. Slack-Mendez, did I pronounce that correctly?
You did, Your Honor.
Great.
And good morning. May it please the court.
Good
My name
morning.
is Charles Slack-Mendez on behalf of Appellee. First, with reference to the jurisdictional issue, my position is this court does not have jurisdiction to decide this case on the basis that a final award and judgment was entered. And I will start out with Rule 77 of the rules with ARS, with Rules of Civil Procedure, which basically states that after an arbitration, one may appeal within 20 days from the award or 20 days from notice of decision, whichever is first. Here, the decision was actually was called a ruling, and it was a 13-page ruling. I mean, this was a fairly extensive ruling on the case. Only 20 days they have after that decision was done in order to appeal. And the proper appeal would have been to Superior Court. It would have been what should be titled under Rule 77, appeal from arbitration and motion to set for trial. That was not done. But let me back up.
And it wasn't done whether we count from the notice of decision or the document called judgment.
That is correct.
I think everybody can agree there was no appeal, but you're arguing that the document called a judgment that I think it was signed January 29 and apparently filed with the Superior Court that same day. You're arguing that that is a final judgment?
That is a final judgment.
How about the problem, if there is one, that it's signed by the arbitrator, not by a judge or commissioner?
Well, Your Honor, that's a very good question. And my explanation to that is we had an arbitration that not only dealt with the merits of a breach of contract matter, but also dealt with attorney fees.
But they always do.
Well,
But the question isn't what the content of the arbitration was. The question is, who is it that is making this a judgment and putting it into the record, isn't it?
okay.
I'm sorry, go ahead. Answer Judge's question.
I mean, are we going to sit down and say that judges and commissioners are only responsible for signing certain types of judgments, and this wasn't a judgment that qualified for that?
I'm getting to answer your question. And why I'm making that distinction is because Rule 58A of the Rules of Civil Procedure states that a party seeking attorney fees shall provide in the form of judgment for an award of attorney fees in an amount to be entered by the court. In other words, it's saying if an arbitrator, which is acting in the same capacity as a judge, he's in fact a judge pro tem, if such arbitrator, according to Rule 58, is going to enter an award of attorney fees, they need a form of judgment, according to Rule 58, along with the affidavit for attorney fees.
Where do you get that the arbitrator is acting as a judge pro tem?
Well-
He's acting as an arbitrator, and where the judge or a commissioner will hold a trial de novo if an appeal is taken.
Okay?
What's your authority that, let me ask you this.
Well-
Let me ask you a different way.
Okay.
What's your authority that says an arbitrator is a judge pro tem?
I do not have that authority, Your Honor. All I can, I guess, my counter argument to that is the arbitrator is in fact acting as a trial of fact of the case, and in acting as such, he makes a determination as to what would be a reasonable amount for attorney fees, and therefore he would be acting to enter an award for attorney fees.
What I think I hear you saying is that 58 addresses attorney's fees, talks about the judge, and because am I correct in following you that because the arbitrator dealt with attorney's fees here, I guess, in the judgment, I don't really remember,
Well,
that because of that, it makes the arbitrator functionally a judge for this purpose?
or he is entering not only an award, but he's entering other final dispositions on the case.
But final from the arbitration.
From the arbitration, correct.
Because what we know is that the structure post-arbitration anticipates that the Superior Court then becomes very active in the process.
If an appeal is taken.
Or a motion to confirm is filed.
Or-
I mean, the rule anticipates that either the person who lost an arbitration is going to take an appeal and they ask for a trial de novo, or that the person who won in the arbitration is going to move to confirm the arbitration award.
Regardless, the Superior Court ends up being the one that addresses the final disposition.
The Superior Court is the one that enters the final order. That would be my position. In fact, under Rule 58, it says the filing with the clerk of the judgment constitutes entry of such judgment.
Right.
So the actual filing itself, we've got two situations, judges. One is we've got arbitrations and we've got non-arbitrations in Superior Court. Why should the procedure and the hurdles that need to be jumped be different for arbitration than for trial? If this matter had been in trial,
Because of the Seventh Amendment.
well,
If we said, you have to go, you have a civil cause of action, and you have to go to arbitration, and you lose your right to a jury trial, that arbitration becomes final if you don't appeal, then there's a real Seventh Amendment issue here. I think that the answer to your question is that if the person who loses in the arbitration wants to have a jury trial, all he has to do is file the appeal, and he gets him trial de novo, and it can be a jury trial.
I may have misspoke as to what I was getting to. The issue was, if this case had been tried in Superior Court, the courts enter its ruling, one would submit a form of judgment, and that gets signed.
Yes.
But it was being tried in the Superior Court. Wait a minute, hang on. It was being tried in the Superior Court. It was filed in the Superior Court. It was moved into the mandatory arbitration. It was addressed through the arbitration rules, and then the rules anticipate it comes back and is finalized in the Superior Court.
Yes, that is correct. And then when it gets moved back to the Superior Court, once the decision is made and the arbitrator signs, which in this case was a judgment, then that should be entered as an award as a record of the judgment.
But doesn't that then completely obviate or do away with the requisites of the rules regarding how this Superior Court matter is being handled through arbitration?
I do not think so, Your Honor. With Rule 76 of the Rules of Civil Procedure, under subsection C, it says, upon expiration of appeal, which that's what we had here, if no appeal has been filed, any party may file to have judgment entered on the award.
Right.
Okay? So we've got the arbitrator who files a ruling, in essence, an award, and then subsequent to that, and after the appellate time has expired, a form of judgment is submitted, which is signed by the arbitrator.
And I take it that and I'm moving us ahead, perhaps for the moment at least, to bring in Section 12133E, which we want to talk about. The middle sentence that Judge Kessler brought up a few moments ago with Mr. Stein, the middle sentence says the court shall enter the award in its record of judgments. I guess I'm assuming that your position is that when the arbitrator signed the judgment and sent it to the Superior Court and it was filed in Superior Court, I guess I'm assuming your position is that by that filing, by the court, that the court had entered the award in its record of judgments right then.
That is correct, and that's my interpretation of rule of ARS 12-133, specifically when it's talking about the award has the effect of a judgment.
Was that done? Did the arbitrator, I wasn't aware.
The arbitrator filed it in Superior
The
Court.
arbitrator filed the award?
Filed a judgment, signed judgment.
Signed judgment, and filed it with the Superior Court.
With Superior Court.
Yes.
So there's a judge that is the Superior Court judge that is assigned to this case.
Yes.
That Superior Court judge sends the matter to arbitration. It comes back from arbitration with a judgment signed by somebody who is not the judge to whom that case is assigned. That person files that judgment, as it's named, award as it should have been called, in the record, and then the Superior Court judge is just bound by whatever it is, procedurally correct, legally correct, whatever, that Superior Court judge is basically bound by the decision of the arbitrator.
Unless an appeal is filed in Superior Court, and then we've got a trial de novo.
When does the appeal have to be filed?
It has to be-
Because if you have a ward or
Yeah,
a result or a ruling,
and excuse me for interrupting, but can we distinguish between the appeal to Superior Court after the arbitrator and the appeal to this court after a judgment?
you're saying in 133,
Did
the
I-
appeal is the appeal to the Superior Court?
Did I mess up your question?
No, but I just wanted to clarify. I think it's a good, I'm so glad you're here. The
Me
appeal,
too.
the appeal is, you're saying in 133, the appeal is the appeal to the Superior Court?
Appeal to Superior Court, correct.
So now, when does the appeal time begin to run? From the quote, result, or from the filing of the award?
Well, if my understanding is that if no appeal is entered, or no notice of appeal is entered, and then, according to Rule 77, the notice of decision becomes an award under Rule 76B,
76B.
correct?
But that's when that 76B provides an alternative procedure if, I believe 76 contemplates a notice of decision and then an arbitrator will enter an award. But 76B provides a fix if the arbitrator doesn't enter an award by saying the notice of decision becomes the award.
So
So then 20 days after that.
Correct.
Right, so what you're saying is that the person who wants to seek to appeal to the Superior Court has to do it from in this case, from the ruling? And if he doesn't file the notice of appeal within timely manner from the ruling, the arbitrator can then enter judgment?
Well, it's not what
Is that
I'm
what you're reading
saying. It's what appears Rule 77 is saying. Rule 77 says that if somebody wants to appeal, they've got 20 days from the award or 20 days from the notice of decision, whichever is first, to file their notice of appeal. If they do not do so, and then the notice of decision becomes an award of the court.
But are you saying here that under 77A, well, and its reference to 76B, are you saying that on January 3, 2013, when the arbitrator issued the lengthy ruling you mentioned, that there was no subsequent award issued by the arbitrator, and so the 20 days ran, well, are you saying the 20 days started running on January 3?
That is correct. The 20 days start running on January 3rd, and then after the 20 days, the arbitrator entered the form of the judgment.
That is a creative way of looking at this. I will give you credit. That is a creative way of looking at this.
Well, that's my interpretation of the statute.
No, I'm not being critical.
Okay.
It's a creative
Okay.
way. So therefore, there's a judgment. And now there's a motion to dismiss, and that's denied. Why is that? Why don't we have jurisdiction over that? Wouldn't that be a post-judgment order?
Well, number one, this motion to dismiss, I believe, was filed probably a year or two after this case was.
Understand. I'm just talking about jurisdiction.
Right.
Why wouldn't we have jurisdiction as it being a post-judgment order that somehow affects the rights of the parties? I'm not
Because,
saying it affects the merits. I'm just saying, why don't we have jurisdiction over that?
even though the minute entry from Superior Court did not give an explanation for their reasonings for denying the motion, my assumption would be that the fact that they denied such motion is in fact affirming that there is a judgment and there is a final order.
But there's a separate statute that allows us to take appeals from post-judgment orders that affect the rights of the parties. Why wouldn't that be one of them? I mean, or isn't your opponent between a rock and a hard place in essence? Even if you buy into the argument that what the arbitrator filed is a final judgment, you can't appeal from that because the time's run. He then files a motion under the rules to try to get that to get the whole matter dismissed. That's denied, and then he can't appeal.
And my position is his time ran. I mean, it's,
But he's not appealing from the arbitration award. He's appealing from the order denying the motion to dismiss.
but the actual motion deals with the merits of whether it was a valid judgment or
I
not.
understand that.
Right.
I'm just saying, why shouldn't he be able to appeal from that? We could say, yeah, we have federal jurisdiction, but you're wrong.
Well, if it's a question for me, my answer is no.
But let's assume hypothetically that we do not buy into the position that we buy into the position we don't have jurisdiction, but we're going to take special action, and we think that the arbitrator cannot enter an award, a judgment, and the court should have granted the motion to dismiss. Should it be dismissed with prejudice, or does the court have discretion to dismiss it without prejudice?
Well, if this court would be looking at the best interest of justice, the appropriate, I don't think the statute specifically states whether it should be with or without prejudice. But I guess if we're looking at the interest of justice and the fact that the statutes do permit a judge in superior court to enter an award
Enter a judgment.
on their own, correct? And the fact that the aggrieved party has prevailed in this arbitration, it would seem only fair and would seem that it, in fact, would be in the best interest of justice to allow the appellee to submit the proper form of judgment and therefore be dismissed without prejudice.
It's sort of like a lack of prosecution, lack of prosecution. In other words, gee, I didn't file the motion to confirm. And assuming we bought, and I'm not asking you to give up anything, to concede anything, but assuming that we found that there had to be a motion to confirm, and there wasn't a motion to confirm, and that's sort of like a failure to prosecute, wouldn't it be? And therefore, the dismissal should be without prejudice. It wouldn't be on the merits. Isn't that, I mean...
Yes, and then again, there's rules that deal with catch-all type of deals where the court would determine the best interest despite what transpired here. I mean,
You have 41B, which allows the court discretion to dismiss without prejudice, and you have the savings statute.
Right.
That talks about dismissals without prejudice when you haven't reached the merits.
that's correct.
In the remaining moments, could you tell us your position on whether Rule 76 clashes with 12-133?
It appears to clash under my reading of it. I mean, one seems to, the actual statute seems very clear in stating that the award has the effect of a judgment.
What does that mean?
Well, we don't know. I mean, I can interpret it the way I want to interpret it. The effect is, it is a judgment. That's what it means to me. But, we've got so many litigants pro per that go to arbitration because the amount in controversy is such a low amount that they can't even hire an attorney. And if we're here debating what effect means, I can guarantee you the average litigant, non-law educated, has less of an idea, and I don't think that this court would want to impinge upon their ability to collect on a case they've proven on merits on something as simple as what does effect mean.
Are you saying then that the effect is the same as shall constitute?
Yes.
Okay.
Your time is up. Thank you very much, Mr. Slack-Mendez. Appreciate it.
Thank you.
And Mr. Stein, we have 2 minutes and 17 seconds. We apologize for being stickler on the time today, but we have 3 arguments, so we're trying not to fall behind.
I will be brief. There are just a couple points that I wish to reiterate in the few moments I have left. First is there's this notion that the arbitrator in some fashion served in an official judicial capacity as a judge pro tem or some other sense, some other way. There's absolutely no authority for that proposition. The rules are well-founded, well-established, that the arbitrator rules on the merits, including an award of attorney's fees, including a variety of other issues, except a few that are parceled out to the court.
I would think that if an arbitrator were a judge pro tem, he would be applying to the Maricopa County Superior Court to be paid as a judge pro tem.
Indeed, and that would obviate the entire body of rules dealing with arbitration. There's simply no support for that proposition.
Is there any support for a notion that the Superior Court judge assigned the case, the Superior Court judge assigned the case, would have his ultimate authority in regard to entering the final judgment obviated by the filing of an award by an arbitrator?
Of course. I mean, the rule 76C and D couldn't be clearer. The procedure is notice a decision. If the notice of decision doesn't ultimately blossom into an award, that's deemed the award. And another point that I wanted to make is the 20-day appeal period only starts running when the notice of decision constitutes the award for lack of an award. It doesn't, there's not a 20-day period from the notice of decision, but the rules, Judge Jones, is very, very clear. The arbitrator has certain authorities expressly delegated by rule, and the rules then adopted by the Supreme Court say if you want a judgment, you apply to the court for a judgment, the judge signs a judgment, and that is the finality that is brought to the case. And if one doesn't timely bring that judgment 120 days after the notice of decision is filed, the case is dismissed. It can't be clearer. The Supreme Court has spoken on this point, and I think it is incumbent upon this court and the Superior Court to implement and fulfill the rules that the Supreme Court adopted. We ask that an order be entered directing the Superior Court to dismiss. We also seek an award of attorney's fees on appeal.
Thank you both very much. We've appreciated your arguments. It's very interesting. We will do our best to grapple with the rule and the statute and issue a decision in due course.
Thank you, Your Honor.